The judge enters a judgment against you. You've done asset protection, but now what happens? My name is Jonathan Alper, and I'm an asset protection attorney in Orlando, Florida. And many times I get calls from my clients for whom I've done asset protection planning months or years ago, and then they call me up all of a sudden and say they lost the case and now there's a judgment against them, so what happens? After a judgment is entered, there's a 10-day period for rehearing, and in most cases, a creditor will wait at least 10 days during the rehearing time until they pursue collection activity. But in the meantime, when a judgment is entered, the court will usually attach to the judgment a separate sheet of paper, which is a list of questions about your assets. It's a very brief financial statement, which we call in Florida the fact information sheet. And the judgment debtor has 45 days to fill that out. And that fact information sheet asks general questions about your financial situation, such as list your bank accounts, produce your last 2 tax returns, list any properties you own, and list any transfers you made in recent years. And it's important that you fill this out accurately because it has to be submitted under oath. And many times judgment debtors will not take it seriously because it's just a form, and then this omissions on this form can be used against the debtor to impeach him because he testified under oath but omitted some of his assets. So be careful when you submit this form. It is under oath. After the creditor receives the fact information sheet, or in some cases before it's received, it's up to the creditor, but the next tool the creditor usually uses is to ask the debtor to produce documents. Documents relevant to the debtor's financial situation, such as not only tax returns, but maybe copies of checks from previous bank statements, copies of credit card statements, copies of car titles, deeds, IRA documents, anything the creditor may reasonably request to discover what assets the debtor has and where the debtor is receiving money and paying money. So when you submit a bank statement or a statement from a brokerage account, that statement will show all the deposits and the checks, and the creditor will ask you where all this money came from, what other assets are sending money into your accounts. The next tool that the creditor has is to take the examination in a deposition of the debtor under oath and ask them about the documents and inquire about the debtor's financial situation. This is called a deposition in aid of execution. And the law gives the creditor very broad discretion on what he could ask you, the debtor, about. Anything that's relevant to present or past financial situation is proper. Can he ask about your spouse's situation? Yes. Can he take the deposition of your spouse? Yes, he can. The creditor has broad latitude in uncovering assets. As assets are uncovered, then the creditor has certain tools in his toolbox to collect the judgment from various types of assets. There are specific tools that the creditor can use depending on the asset. For example, if a debt is owed to you, the debtor, from a bank, from an employer, or maybe just a friend, that debt can be garnished. And the tool that the creditor uses is the writ of garnishment. If you have personal property, a car, for example, the tool is a levy and sale. So the creditor can have the sheriff levy on this personal property, like the car, and sell it at an auction. Right? If you own real property, land, a house, other than your homestead, the tool is a foreclosure. The creditor can record the judgment in the county where the property is. That recording of the judgment will immediately become a lien on the property, and that lien's not going away. And then the creditor can foreclose a lien just like your lender can foreclose a mortgage, have the property sold. The money would first go to the mortgage company if there is one, but then the creditor would get left over. So this is a complicated area of the law. There are various tools available to the creditor and various defenses available to the debtor. If you've been the victim or have received a judgment, and you need help defending the collection, give me a call. My name is Jonathan Alper, and my number is 407-444-0404. And thanks for watching the video.